Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. And whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Well, good morning, everyone. Here we are bright and early on Tuesday morning again. This is the Bottled Business Sense show. I am one of your co-hosts, Rick Moscoso. I'm here with Bill Bernard.
Good morning, Rick, and good morning, everyone. Glad to be back with you today. We're looking forward to having another great show and talking about business and protection and promotion of that business.
Absolutely. Well, if you are a first-time viewer or listener here on the Bottled Business Sense show, welcome. We are here every week, every Tuesday morning at 10 a.m. You can watch us on our simulcast on our website at bottledbusinesssenseshow.com. You can also see us or listen to us on Blog Talk Radio. And you know, we're a business and legal simulcast show, and we share information on legal aspects, marketing aspects of small business. And if you have any questions that you'd like to feed into the show specific to legal or marketing, please feel free to send that in to us at our Gmail address, and that's bottledbusinesssenseshow@gmail.com. You can also reach out to us on social media. On Facebook, LinkedIn, Google+. You can click on any of the social icons here on the site, or send us a tweet at bbsenseshow. So with that,
we, like it says under our logo, Rick, on our website, we're here to we provide strategies that protect and promote the growth of your business.
Absolutely.
That's it in a nutshell, right?
That's what we do. At least that's what we try to do.
That's right. That's right. That's our aim here every day, or every Tuesday.
Yep, absolutely. Well, we have an interesting, very interesting topic today that Bill's going to share information on, and that is non-competes.
Yes, listen, I have had a lot of feedback. When are you going to speak about when you're going to do something on non-competes? And in fact, I'm consulting as we speak with a couple of clients who are interested in non-compete issues. So I decided we better do a show on it, and we better address some of the issues as succinctly as we can within the time allowed, so we were able to provide some information to the viewers and listeners out there about where they actually stand in California. There's going to be an interaction sometimes between California and other states, largely because, Rick, there may be businesses that are headquartered somewhere else but are doing business in California. So let's start with the basics overview, and that is, in California, we view restrictions on trade, which is prohibiting people from starting their own business. We view that as illegal and void. We view it as a restriction on trade. You're working for me, you want to go break off from me and start your own business. It's not right for me to prevent you from doing that. That's the genesis of non-competes. Mm-hmm. And so you have to ask the question, are there certain restrictions on that? Well, yes, there are if you're a business owner dealing with another business owner, and we'll get a little bit into that as the show moves on. But generally speaking, non-compete agreements do not apply to employees in California. Rather, if they do apply under certain restrictions, they would apply to owners of a business, shareholders in a corporation, partners in a partnership, or members in an LLC. I can't stop you from going out and starting your own business. If you want to go out and start the same business that I'm in and compete with me, generally speaking, if you're my employee, I can't stop you from doing that. I could stop you from doing certain things, but I can't stop you from getting in and starting up your own business.
When you said when you mentioned certain things, and I'm sure you probably roll into that a little bit in the show, so I'll leave it with that.
All right. Well, no, it's a good question, and we can address it now because there's a distinction. Although a lot of people don't realize it, there is a distinction in this state between violation of trade secret laws and non-compete agreements. So if Rick Moscoso is working for WFB Legal Consulting Incorporated and I have a customer list, for example, that I've developed over the years, and I worked hard at developing that list, I might say that it's inappropriate for you, Rick, to use my customer list when you get started in your new business. So I can prevent you from doing that under the right circumstances by way of a contract that says you will not take my proprietary information, you will not take my trade secrets. But I can't stop you from opening a competing law firm, assuming you're licensed as a lawyer, because that would be requiring you not to compete with me, and you were merely an employee when you were with me to begin with.
Yeah, well, that makes sense because any type of list or database that you've grown over the years, obviously that belongs to the company, not to not to the employees.
And that gets even deeper because excuse me, under certain circumstances, if this list was hard to come by, and if certain things had to be done just right in order to obtain this list. Especially if I was a lawyer and you were not a lawyer while you were working for me, that calls into question some special expertise that I had that you didn't have. Maybe you were a law clerk or a paralegal and then you became a lawyer and now you wanted to take my list. I would probably be able to prevent you from doing that under most circumstances.
Right.
Now, there's something that even tails off from that. You may want to develop your own list by soliciting the same clients. Perhaps under certain circumstances, you might be able to go out and contact Joe Blow, who was a client of mine or is a client of mine, by contacting him on your own at some point in time. And the question would be, can I stop you from doing that? The argument, I guess, would be where you got the information from. Just by knowing Joe Blow's a client, that's far different than actually obtaining a list from me in order to ascertain who my clients are.
Right.
So again, you would have the freedom, more than likely, of going out and contacting Joe Blow on your own to try to get him to come with you as opposed to with me.
Well, you see this in any type of sales situation where if you're an outside salesperson,
right,
you've developed relationships with customers, and then at some point you decide to go, you leave that company and you go to another company that happens to sell the same type of hardware, software, whatever.
Right.
In that case, you see a lot of those customers kind of change loyalties because they're following the sales rep around.
Sure, and a lot of times it's at their choice, and that's fine.
Yeah,
that's fine. But I want to make sure that everybody has clear in their mind the distinction between non-competes and a contract that prevents you from taking proprietary information, otherwise in some instances known as trade secrets. So let's go back to non-competes for a minute. We talked about whether or not they're legal in California. We said they're not, generally speaking, against two groups of people, employees and independent contractors. But they would be valid with certain reasonable restrictions in terms of time and area covered, how many years and how far of a distance. They would be legal against business owners versus another business owner. You're my partner. You have an ownership interest in the business. You're a member of my LLC. You have an ownership interest in the business. You're a shareholder in my corporation. You have an ownership interest in the business. It would be improper for you to go out and compete against me if I'm still running my LLC, my S corporation, my partnership. Under certain conditions, I might be able to prevent you from going out and competing against me by upholding a valid and enforceable non-compete agreement because you're not an employee and you're not an independent contractor. So under those circumstances, it may very well be a valid and enforceable contract.
So even if that individual that's leaving is removed of the LLC and leaves altogether,
Right. You may be
can
able to
enforce
say, okay, pursuant to our non-compete agreement, if you leave this business has goodwill attached to it, and we're generating money, and part of our business value is that goodwill. We don't want you to be able to go out and take our goodwill and compete against us as the owner of another business when you were already the part owner of this business with us, because you wouldn't have gotten access to that but for being with us.
Right.
Now, remember that if there are instances where your business is operating, you may be with a business that operates in another state, but is doing business in California. Regardless of whatever action is brought in another state to stop you from competing, again, going back, assuming you're an employee or an independent contractor and not a business owner, more than likely the California courts are going to apply a California law, so they're not going to be able to stop you from competing if you're an employee and an independent contractor against a business that is doing business in California, for example, but may be based in the state of Florida. Okay?
Yeah.
So that's an important point. But generally speaking now, if you're the owner of a business and you're held to a non-compete, again, you're not an employee or an independent contractor, the point we were just making a minute ago is distinguishable from the standpoint that the non-compete must be reasonable even against a business owner or a member of an LLC or a partner or a shareholder in an S corporation. It must be limited to a reasonable period of time, and it must be limited to a reasonable area. You can't say, because you're my business partner and now you're leaving, and I would otherwise have a valid non-compete agreement, I can't say, well, Rick, you can't compete in the entire 50 states with me. And you can't compete until you die, Rick.
Mm-hmm.
Of course, you wouldn't have a need to compete then anyway, right? But the point is, you have to have reasonable restrictions within the non-compete, even if it does apply, because you're a business owner, a business partner, a member of an LLC, or a shareholder in an S corporation.
Right. Yeah, I've seen situations where, my previous life I worked in the medical field, and you see officers of the company who get courted by the competition, and they decide to leave that company. But I've seen situations where they've had to wait a year because of some kind of non-compete clause before they actually started work for this other company.
Mm-hmm. Mm-hmm.
So that's an agreement, obviously, that has to be done right up front when they
yes, it does. And the other interesting part that we should mention is, and this is where having a good business attorney on your side really matters if you're in business with somebody.
Mm-hmm.
You've got that legal entity, whatever it might be, that protection is set up for you. Most attorneys who are worth their weight in salt set up in the operating agreement or do a subsidiary or a side agreement for non-compete. In most operating agreements, for example, or articles of organization might address the non-compete issue. So when you're going into that LLC or that S corporation or that C corporation, you know right off the bat that you're partaking in a non-compete agreement. Okay, so it's not something that should come out of the blue or be asked. Now, if you don't have one up front and you're an owner of a business with someone else and someone, they get together and they say, we want you to sign this non-compete, let's all sign this non-compete, that makes sense and it's perfectly acceptable, but it really should be addressed up front.
Mm-hmm.
You shouldn't be doing these things at some subsequent time after the business is formed.
Right.
I think we should talk a little bit about what happens if you get fired by signing a non-compete. But before we do that,
you have let's do a little commercial break here.
We need to do a commercial break, and we want to let everyone know. This show stemmed from a newsletter that I created called Bottle Business Sense, and Bottle Business Sense newsletter comes out every month. And it can be found at bottlebusinesssense.com. We then started the Bottle Business Sense show, at bottlebusinesssenseshow.com. And as a takeoff from both of those, I have been doing for the last 6 months a small publication called Bottled Protection Points. And Rick's going to be able to show that to you. And the one we have today, as a matter of fact, is premised directly on the issue that we're talking about today. And it states, in order to uphold a covenant not to compete, a contract for sale of a business may not circumvent California's deeply rooted public policy favoring open competition. Otherwise, the non-compete agreement is void. There must be clear indication that in the sales transaction, the parties valued or considered goodwill as a component of the sales price. We talked about that. Also, a covenant not to compete will be enforced only to the extent that it is reasonable and necessary in terms of time, activity, and territory in order to protect the buyer's interest. That means the remaining owners of the business you're leaving. Likewise, if you sell your ownership in a business, you can be prevented from turning around and soliciting your former customers and taking them from the business you sold. This is to protect the goodwill and the value of the existing business. That means you can be restricted by not taking proprietary information. So these are little like bottled protection points that are blasted out there on all of my sites, LinkedIn, Twitter, Facebook. And they can also usually be found as a posting on the initial posting page at Bottle Business Sense newsletter, which is bottlebusinesssense.com.
And these protection points come out every month?
Every month, although I'm starting to do them more frequently. I can't promise that they won't be more frequent than every month, but at least every month, yes.
Okay. Excellent.
Okay. So having said that, let's get back to the show, and let me talk about let's intermingle now some employment law into this. And, this is the wonder and beauty about business. I've always said be a really good business lawyer. You need to know asset protection. You need to know estate planning, the protection points, if you will, for both a business and personal estate. And then you need to know employment law, because if you have this business, you may have some employment issues. Mm-hmm. And at the root of all of those three prongs of a business lawyer's business is the preparation of contracts. Everything stems from a contract. We're talking today about non-compete agreements. So what happens if you're fired by your boss for not wanting to sign a non-compete? You can refuse. Again, now we're going back to talking about an employer and independent contractor, because those are the only people that can be fired, right? You can't. You're not going to fire another one of your business owners. You can bring an action for wrongful termination if you refuse to sign one and you're terminated. You have to be careful, because as we spoke about before, there's a distinction between being asked as an employee and an independent contractor to sign a non-compete versus a proprietary agreement, which protects trade secrets.
Right.
It's interesting. I wrote down this case called Silguero, Silguero versus CrateGuard Incorporated. That's CRETEGUARD Incorporated. Here there was a wrongful termination claim made. An employee had an illegal non-compete agreement with her employer, which prevented her from engaging in sales activity post-employment for 18 years. So not only was it egregious in terms of time, but it was an employer imposing a non-compete on an employee. She joined a new company, and her old employer told her new employer that she had a non-compete. Out of respect for her old employer, the new employer fired her. So she had a wrongful termination claim against the new employer, not the old employer, because it was the new employer enforcing this other agreement. So, and this happens more often than you think, where the new employer, even though you're competitors, you may have a mutual respect for each other, and one old employer calls up the new guy and says, by the way, she can't come to work for you, she can't do this because we have a non-compete with the old company, and she's violating that. Well, not only shouldn't she have been forced to sign that to begin with, but now the new guy is taking advantage of the old guy's agreement and basically preventing her from being employed. So you could have a wrongful termination claim that in that case, I would bring the claim against both the old employer and the new employer.
Oh, so she could bring claim against the new employer.
I would bring. There would be a number of other claims that you could add as well. One of them perhaps being interference with prospective economic advantage, where you're now preventing me from going in and getting a new job with a new employer because you're telling him about this agreement, which is invalid to begin with.
So really, who's at fault then in that case?
Well, there could both be at fault.
Yeah.
The new employer for preventing her from coming on board, and the old employer for telling her the new employer about the agreement to begin with, and interfering with her ability to conduct free enterprise. That's what this state is based on. It's our general view that we take, as long as you're an employee or an independent contractor. So we talked a little bit, Rick, about soliciting former employers' customers, and we talked about the distinction between a non-compete and a trade secret agreement, or otherwise known as a proprietary agreement, proprietary information agreement. I want everyone to remember that just because a non-compete is illegal in California, it does not mean that an employer does not have trade secrets. Just because you can impose a non-compete on an employee or an independent contractor does not mean that I, as your employer, do not have trade secrets. No, I do, and I can enforce those, even if you're an employee or an independent contractor. So if you take, we talked about this before, let's say you take a customer list and use it to solicit new business, or your employer may be misappropriating your former employer's trade secrets. Who knows? You can be prohibited as an employee or an independent contractor from using trade secrets, confidential information, proprietary information, whatever you choose to call it. You can be prevented from using that information.
Well, that makes sense because, again, working in a high-tech medical the industry for a while, I was required to sign an NDA upon employment. So
right.
that would be something that would be applicable to what you're talking about, right?
Right. That's exactly right.
Yep.
Let's go to another short commercial break before we finish the show up. There's a lot of good stuff here that we want to get to, but before we do, we want to advertise a show coming up on November 4th of this year, where we have a very special guest, Steve Smith of Growth Source Coaching, and he is a business coach that we hold in very high regard, who's helped a lot of people. Not only start a business, but do a lot of what we do, keep that business moving forward and prospering. And we work a lot with him, and we refer him to people. And he's going to be on the show talking about various aspects of marketing and what you need to do. He's a marketing consultant wizard and a coaching genius. So I think it's going to be a very fascinating, interesting show. Yeah. And we hope everybody tunes in and takes advantage of that.
Yeah, it was great. I was on a recent webinar watching him talk about one of his success stories with a client that he had back in the Midwest, and I was just fascinated how he took this guy from where he was at to really organizing his thoughts, delegating some of the menial tasks that he was typically, basically wasting his time with, where he should have been
overwhelmed.
He was overwhelmed, and his best time, especially as an owner of the business, is really speaking with clients or prospective customers out there. Right. And I think Steve, through his way to communicate with, through his coaching program, has enabled him to stand back and be a third-party objective viewer. And just really just say, you're focusing your time on the wrong
He is really
spot.
An organizational wizard.
Absolutely.
That is really a tremendous strong suit of his. Yeah. So we hope everybody tunes in on November 4th and feels free to call in and ask Steve some questions and participate. We'd love to have you do that. So We'll look forward to that.
Great.
Okay, so let's get back to our show and let's mention that it's important to understand that a contract term saying an employee cannot solicit customers for 12 months post-employment is an illegal non-compete. Why do we say that? Because we're telling an employee that he can't solicit customers for 12 months. Mm-hmm. So there's a number of things wrong with that. We have an employee, We have telling him he can't compete by soliciting customers. We're not saying anything about taking any list, right? And then we're also saying it's for 12 months. That may not be so bad at 12 months if it was a legitimate non-compete. But that would be an illegal non-compete under the example we just gave. However, a contract's term saying an employee cannot use confidential company information to solicit customers post-employment is a valid contract, but it's a valid what? It's a valid non-proprietary. It's a valid proprietary trade secret contract.
Mm-hmm.
Has nothing to do with competing, because he can compete as an employee. He just can't take my proprietary information and do so.
And that would be equivalent to or similar to the NDA that I was speaking about,
Exactly
non-disclosure
right.
agreement.
Excuse me, exactly right. So what does this mean? It means a non-compete cannot be enforced to prevent someone from taking a job because you believe they will use your confidences as part of their job. Instead, you have to prove that the former employee actually misappropriated your confidential or proprietary information. He can go out and do what he chooses to do to compete with you. If you want to accuse him of something, you better be able to prove that he took your proprietary information and is using that to compete with you.
Right. So when you're talking about the non-compete, I understand it's illegal here in California, but is it that applicable to other
Illegal
states?
for employees and independent contractors.
Is it just in California or in California?
No.
Just-
There are different. A lot of other states are not as liberal as California in that regard. So you have to check each state depending upon where the law is going to be enforced in that agreement. If you're in Florida, for example, and you're working in Florida, and the California that company is doing business in California, or if you're in or if the company is headquartered in Florida doing business in California and you're in California, the contract will tell you, the non-compete will tell you what law of what state is going to be applied to interpret that contract. So you may have a good example. This is a great question, Rick. You may have a non-compete that says we're going to use Florida law. Okay, and now you're going to compete, right? We're going to hold you to Florida law, which doesn't say, and I don't know for sure, I'm just using this as an example. Let's say Florida law does not prevent non-competes against employees and independent contractors, and you're an employee for that Florida company working in a factory in California where they also do business. And they say, now you're leaving our business in California and you're going to go compete with us. So you can't compete. Well, maybe under Florida law that would be upheld if that contract says Florida law must be applied. But on the other hand, it may be stricken down if it says you can't compete with us in California for 10 years. Well, California is 3,000 miles from Florida, and the court may interpret that as being too much of a distance away, and it may also say it's too many years, 10 years. So you have to have reasonable prohibitions, even if a non-compete is found to apply generally. You then have to look at the conditions under which it's going to apply to finally determine if it's going to hold up.
Let me ask you a situation then, because it's interesting that you say that. The distance obviously separates a little bit in your example, but what if, let's say you and I were real estate agents, right? And we co-owned a brokerage. We were principals in that brokerage, and I decide there was some disagreement, or we decided to just spin off on my own. What would stop me from continuing my own brokerage, right? Separate of what we had together, but yet continue in Orange County.
Okay, so when you're with the initial brokerage, you are a real estate agent working for that broker, and then you obtain your broker's license, and now you go out and you want to be a broker yourself.
Well, let's say you and I worked out of, we had XYZ real estate agency.
Okay.
You and I, right?
And who's the broker?
We both are. Let's say
you're both brokers.
Let's say we both are.
Okay.
All right. We own the agency.
Okay, all right.
All right.
Sounds good.
And then something happened, whether good or bad, something happened where we decided to part ways. But we're not moving. We're still in Orange County.
Mm-hmm.
You do your thing. I do my thing. Right. What kind of things would apply?
Do we have a non-compete in place?
Yes.
Okay. I think that since we're sharing in the business and making money in the business, and we have our business set up, more than likely, if you're going to do that, you're going to have some form of business entity.
Mm-hmm.
Then yes, as a business owner, where you're both brokers sharing in the profits of the business, a legitimate non-compete, I believe, would be able to stand up as long as it's reasonable. Now, if he tells you can't compete within, 30 miles, 50 miles, 100 miles of the office within 5 years, that might be interpreted as a reasonable construct for that agreement. And remember, unless somebody challenges a non-compete, the terms are going to be presumed as reasonable, right? Because you signed it knowingly.
Right.
If you decide that it's unreasonable terms, you're either not going to sign it to begin with, or you're going to realize you made a mistake and try to challenge it based on whatever information has come into your possession. You speak to your lawyer. Some cases have come down that he points you to, and you say, this could be interpreted as an unreasonable distance or an unreasonable period of time. Well, then you wouldn't be able to compete. That agreement would hold up unless it was challenged, and now you're off doing your own business, now gaining new clients, and doing so within a different area, right? You're going to probably move out of the area that covers the non-compete, and then you're going to be able to solicit clients of your own based on the new area that you're in that's outside of the coverage provided by the non-compete. Now, let's say you have the same big clients. The non-compete could very well cover the fact that as part of your dissolution or part of your breakup, you're not going to sell property for this big client for a certain amount of years, or you're prohibited from soliciting this client for a certain amount of years to sell property on their behalf because you're leaving the business. What happens, however, if we take that a step further and that client now solicits you? What if that client wants to do business with you? My interpretation of that would be that if that client wants to do business with you, that non-compete is going to be very difficult to preserve, because while you may say a non-compete covers X, Y, Z, it's going to have to be interpreted as a requirement that X, Y, Z wants to be covered. So if you have a big client that you're both doing work for, and this client decides to go with you when you leave, you're not actively out soliciting.
Right.
So
It's their choice, right?
it's their choice. Right?
Yeah. So, okay, let me throw another scenario out to you quickly. Same scenario. We were in business together. Now we're going through a dissolution. No, I take that back. We're not splitting up, but there is a business person who has come to you, right?
Okay.
And wants to work on a different project together within the real estate. Let's say it's educational products, right? How to train other real estate agents to set up their brokerages. But they've just come to you because you're an expert in education and training and all that stuff, but doesn't necessarily want to be part of you and me.
Okay.
Is there anything that's stopping you from working with that guy to do this other product?
Is that other product in direct competition to what you and I do?
No.
If that from what it sounds like, your example is merely indicating that this person prefers dealing with me. He wants to deal with our business, but he likes me and doesn't really.
Well, no, you have the expertise.
Okay, but you are also an owner of the business,
Right.
so you're going to share in the profits that our business makes, right? Even though I have the expertise that you don't.
Mm-hmm.
If we're in business together and we have a business entity, whether it be an LLC or S corporation or C corporation, whatever profits come into that business are going to be split up according to our agreement. So whether he does business with me or you is not going to matter under those circumstances, assuming that our agreement says that we're going to share in the profits either 60-40, 75-25, 50-50, whatever it is, those profits are going to be split up pursuant to our agreement and when we establish the entity.
Okay. The reason I ask is I see a lot of this going on.
Does that answer it?
Yeah, it does.
Okay.
The reason I ask is because I see a lot of online entrepreneurs are that are selling information, right?
Mm-hmm.
They have, whether it's Facebook marketing or Twitter marketing or whatever.
Right.
I see a lot of partnerships that go on to a specific product, maybe that they're launching.
Right.
But every product that they seem to launch may not be with the same person, but with another expert in a certain field of marketing.
Right.
Right. And I guess I'm trying to understand or help the viewers understand how they do that if it's with a different person for every project.
Well, I don't know. I totally get what you're trying to get at. What I think you're saying is there are a group of business people together that are in business together. They're all owners of that business, and now they are doing business with different outside contractors or other businesses, using each time coming into a situation where they're going to be buying or selling a different type of product or service. Mm-hmm. So the real meat of your question is what? Because whenever that company deals with whoever they're dealing with outside, that money coming in will then go into the pot and will
for the company.
It will for the company itself, right?
Right. Yeah.
It's not going to be an individual dealing with somebody outside as an individual. It's going to be the company, just because one person from the company may be the contact person for this other business outside that they're going to be generating income from. That's got no bearing on it.
Okay.
There's no non-competition issue there. Okay.
Yeah.
And
that makes sense.
And there's no proprietary issue there.
Okay. Great.
Okay. So as a recap on the show, let's recap before we close, and that is that again, generally speaking, non-competes are illegal and void against employees and independent contractors. They can be upheld as long as they have reasonable terms when they are issued concerning business owners. And that would be business owners in a partnership, business owners in an LLC, an S corporation, a C corporation, etc. Remember that there is a distinction between enforcing proprietary agreements, that is the mandate that you cannot steal trade secrets. That is enforceable against an employee and an independent contractor, and that is not the same as a non-compete agreement. And also, I want people to remember that you can't be fired if you're an employee or an independent contractor. You cannot be terminated, more particularly as an employee, because independent contractors can be let go under different circumstances. But as an employee, you cannot be fired for refusing to sign a non-compete agreement. That would allow you to bring a wrongful termination claim. And then finally, when you're dealing with non-competes, remember that they're going to be adjudicated pursuant to the law that's set forth in that non-compete agreement, generally speaking. Okay. So that's it for today's show. I hope it was helpful for everybody. Great questions, Rick, and I hope it was a topic. It seemed to be a topic that a lot of people were concerned about or interested in. So I'm hoping that it was helpful to you.
Yeah, I get a lot of questions all the time about that, and not only for myself, but I hear other people ask the same question. So this was a great topic to help clarify a lot of the confusion out there.
Good.
And folks, if you have any questions pertaining to the show in regards to a non-compete, give Bill a call. He'll be happy to help you out. And Bill, how can they get a hold of you?
Get a hold of me at email bill@wfblegalconsulting.com. My phone number is 949-413-6535 and 949-698-6222. We want everybody to be reminded of our show next week involving Mr. Steve Smith of Growth Source Coaching. Boy, say that 3 times fast. Huh? And also our following show after that, which was our special Veterans Day show.
Absolutely. So we're looking forward to having Steve next week. And folks, you guys have a great week out there. We'll see you next week here with Steve Smith.
Take care and have a prosperous week, everybody.
All right.